And the much talked about local government election in Rivers State has been conducted after the court nullified the earlier one conducted by suspended Governor Similaye Fubara. However, opinions are still divided over the constitutionality of the polls. Some say the sole administrator of Rivers State does not have the constitutional power to conduct a local government election, while others differ on the matter. Vincent Otaokpukpu, constitutional lawyer and public affairs analyst, joins me in the studio for more on this, and we're also expecting Samson Itodo, the executive director, Yaga Africa. He'll be joining us on this conversation from our off-site studio. But let's begin with you, Vincent. Very warm welcome to Newsnight.
Thank you for having me.
How would you describe the council's elections in Rivers? The people have spoken and they said it was peaceful, free, and fair.
Yes, it does not matter the opinion of people in Rivers State. What matters in this contest is the constitutionality or otherwise of the exercise, whether it enjoys the approval of the law, whether the action of the sole administrator in Rivers State is founded in a democratic, under the constitution, as the case may be. Nigeria is a federation governed by law, and every action of government must drive its legal validity and legal validity and effect from the constitution. The constitution being the diagram norm from which every other norms derive its legal validity and effect. Beyond this point, Section 1, Sub 1 of the Constitution states that the 1999 Constitution of Nigeria is supreme, and its provisions shall have a binding force on all persons and authority throughout the Federal Republic of Nigeria. Section 1, Sub 2 provides that the Federal Republic of Nigeria shall not be governed, nor shall any person or group of persons take control or governance of any part of the Federation or any part thereof, except in accordance with the provisions of the Constitution. Having laid this foundation, what is the constitutionality or legality of what has transpired in Rivers State today? Is it known to law? The answer is no. It is not known to law. So the people who might be myopic, who may be not having full knowledge of the law, may be able to say whatever they want in the court of public opinion, newspaper stand. That does not count in the real sense of it. What matters is this, that
the sole administrator.
The sole administrator, the president of the Republic of Nigeria, in the purported exercise of his powers under Section 305 of the Constitution, forcefully removed the democratically elected governor of a state. Now, I have gone through the provisions of Section 308 while coming to this studio, and I tried to see whether there is anywhere contained in that provision where the governor, a sole administrator, properly so called in this context, is empowered to conduct a democratic election to bring in democratically elected governors at the local government.
But must there be vacuum? Must there be vacuum in government?
It does not matter whether there's vacuum, but the issue of vacuum is not.
Isn't it a situation of necessity?
No, it cannot be a child. It cannot be a child of necessity in this context, because there are other offices in the local government administration. There are supervisory councillors and other, what have you. There are other people who can carry out the functions of the local government, not as contemplated by the Constitution. So the issue of necessity does not arise. Now, having talked about Section 308.
Okay, look, we'll come back to that. Let's cross over to our off-site studio where Samson Itodo, the executive director of Yaga Africa, is waiting for us. Very warm evening to you and welcome to Newsnight, Samson.
Good evening and thanks for having me.
Very well. Now, tell us, did Yaga Africa monitor the council election in Rivers State? Because the feelers from the people is that, hey, this is how we want our elections both at the local level, state level, and national level to be conducted.
Well, thank you very much for having me. So Yaga Africa did not directly deploy observers to Rivers State. However, Our state coordinator who runs an organization did observe the elections, and we have received full briefing on what transpired in Rivers State. But I listened to your guest previously and the comments that he made, and I think that he's laid a very strong and solid foundation upon which this discussion needs to be premised, and which is the fact that you have an emergency situation in Rivers State. Can we say that elections can be conducted under the current circumstances and deem those elections to be democratic or credible? My answer is no, because this election itself is an aberration. It totally violates provisions of the Constitution. And we have to make a decision as a country whether we want to uphold the Constitution or we want to govern this big nation, this blessed nation, based on the whims and caprices of individuals that have political power. And it's just unfortunate what actually transpired, today. You can see a weaponization of democratic instruments to subvert the entire constitutional order in the state. The fact that you have an appointed sole administrator, the Constitution, yes, may be silent about this particular issue. You've not dealt with the question of the legitimacy of the state of emergency itself, coupled with the fact that you have a sole administrator. You are now layering that with the conduct of an election that shouldn't be. You clearly see that all of this is driven by several political undertones, and it's just really, really unfortunate. We thought that perhaps when order is restored, then you have a democratically elected governor, you have a state house of assembly. Because at the moment, which law governed the conduct of the local government election? Is it the state electoral law for the state, which we know was in inchoate status before the state of emergency was delivered? Or which regulation actually governed this? Yes, the National Assembly went ahead and approved the appointment, of state members of the State Electoral Commission by the sole administrator. And this itself, it's really unfortunate for our democracy, and we cannot keep quiet in the face of this attack on constitutionalism.
Yes, but the National Assembly, that's the body, administering or providing federal laws and the rest, has acted within its power. Then how do you now reconcile the Supreme Court's judgment which nullified the earlier local council elections? Like I asked my guest here, Vincent, that there cannot be vacuum in governance, and the situation might as well be described as a child of necessity.
I don't think in this case you can say this is a child of necessity. Let's be clear that the Section 150 of the 2022 Electoral Act provides that the procedure for the conduct of local council elections shall be the same in Part 6 that deals with the conduct of FCT election. The reason why the Supreme Court nullified those elections 6 months ago was simply because the local government election was conducted in clear violations of Section 150 of the Electoral Act. This election conducted today also violates the same provisions of the 2022 Electoral Act. And so, when you look at this, the material facts before us, it is clear that we are either ignoring provisions of the law, or we are cherry-picking and choosing which law we want to obey, even when the Supreme Court ruled, upholding that Section 150 is sacrosanct because it compels the procedural conduct of local government elections to the guide, to the provisions and procedure outlined in the Electoral Act. So this election conducted today violates the Electoral Act. Why? Because the issue related to time frame for elections were not met. The procedures for the voting and collation of the results, they were also not met. The issue about notice, all of these factors as outlined in Part 6 of the Electoral Act, vis-a-vis Section 140, they were all broken. And so this election, we cannot say, meets the test of constitutionality. And we have to continually make this point. Yes, politicians, are weaponizing democratic instruments. They are ignoring and acting with so much impunity. But it doesn't mean that men and women of good conscience must fold their hands and just accept this. Because what the political actors want is for citizens to keep quiet in the face of assault to the Constitution. Yeah. And we will not let that happen.
Yes, Samson, it is obvious. Let me come to you now, Vincent Otaokpukpu, that the people have spoken, even in the face of, the lacuna of the law as contained in the Constitution and the Electoral Act. They say, look, they are happy, they are satisfied. What do you want to do? Vincent?
Okay, it does not, like I said before, the opinion of the people does not matter. Exercise of right must be founded in law. Yes, they have right to vote and to be voted for, but it must be exercise of right that is known to law. Permit me to state unequivocally that we must be able to interrogate provisions of Section 197, 198, and 200 of the Constitution in this context for sincere appreciation of the subject matter. Section 197 of the Constitution laconically and copiously provided that the establishment of 1, the State Civil Service Commission, 2, State Independent Electoral Commission, and 3, State Judicial Service Commission. So that is well funded. Section 198 provided that the governor of a state has the absolute constitutional power to appoint members, the chairman and members of the State Independent Electoral Commission, including that of the River State, subject to confirmation by State Assembly, which is maybe, I think, the 3rd majority resolution of the State Assembly in this context. And Section 200 of the Constitution provided for qualifications of members who are supposed to be appointed into the commission. These all provisions, which are conditio sine qua non for a valid conduct of local government election in any state in Nigeria, was not observed and cannot be observed in the context we are discussing today. Whether the sole administrator is a governor within the context of this section and Section 176, which has to do with the executive power of a governor of a state, is another big question to be answered. The sole administrator is not a governor and cannot exercise a executive power with respect to appointment of this commission, as the case may be. Now, the only person that can exercise that power is a governor exercising the right to conduct election in the local government under Section 7 of the Constitution, which says that the state government shall, the system of democratically elected government at the grassroots level is hereby granted, and the state government through the State Assembly shall make law to ensure the administration, finance, as the case may be. So there is no pivot. I'm not scientifically inclined, but I know, according to the Newton's scientific law of gravitation, that you cannot put something on nothing and expect it to stand. It must crumble like a pack of cards. There is no pedestal, there's no yardstick upon which the election of local government election in River State today gravitate. It must crumble like a pack of cards. It requires a courageous judicial intervention to declare every action done today a nullity. And remember, there's action pending before the Supreme Court by some state PDP governors challenging the power of the president to appoint to declare state of emergency in the River State. Assuming that judgment.
Yeah, but isn't it a big, problem of the Nigerian judiciary when issues like this, that actions are expected to be expedited, is like they are slaughtered on the whims of political, grandstanding or non-exigency, Itodo. But what do you say? Let us look at, the action today. Yes, both of you have cited the law. There is no place for it for Vice Admiral Ibaz retired, the sole administrator of River State, to have conducted these elections. But the reports you gathered on the field, what does he say about the conduct of the elections?
I think to the point you made about the judiciary, quite frankly, the judiciary needs to rise to the occasion to deliver, judgments that helps fix the mess that we find ourselves. And it's a mess where political actors, political elites especially, are just on rampage. They are abusing and violating the Constitution and doing so impunitiously without any form of accountability. There's a reason why you have judicial review in a constitutional democracy. And our plea to their lordships is to rise to the occasion to continue to protect, our democracy and regulate this conduct by the political class. Now, when you look at the conduct of the election today, I have said, and I will continue to say, that the procedure for that election violates the provisions of the 2022 Electoral Act. And to that extent, we cannot speak to the legality or the credibility of the election. You clearly see, when you think about issues related to turnout, whether people showed up at the election, I don't think that I should comment, on the quality of an election, which ab initio raises a lot of questions, because doing so will mean legitimizing, this particular process. And it's my respectful view that the election that held today shouldn't have held, and it completely violates provisions of the law.
Well, very, very understandable here from our own point here. But Vincent, let me allow you the final word here. Is the Nigerian judiciary becoming very predictable when it comes to political issues, like adjudicating political issues like this? Sometimes you hear them to say a Nigerian, an individual who's gone to court seeking constitutional interpretation to a subject matter, they'll say it has no local standard. Vincent?
Yes, the principles of local standard is an age anachronistic principles of law, such that for a fellow who have gone to court for grievances bordering on public interest must establish that his right and injury suffered by himself must have existed above any other person. But that rule has been realized by Supreme Court in litany and cornucopia of recent cases, where the Supreme Court have demonstrated as a policy court and the final court in the land that, considering the public interest involved in such litigation, the court have whittled down that scope of local standard principle to allow some litigation for interest of the public pro bono publico. This issue is also sub judice. I learned that a fellow in Rivers State, a legal practitioner, Abayomi, approached the State High Court in Rivers State, and the matter came up 2 days ago, and the ex parte application was not granted to stop the election, and the parties have been asked to be served. The President and the Attorney General and what have you are parties, and the matter is adjourned to 10th of next month. And I know it's sub judice. At the appropriate time, the court will do the needful. But if the Supreme Court, the matter that is pending before the Supreme Court is determined in the final analysis, of which some of us are progressively asked the Supreme Court, I want to see the progressive Supreme Court. We have to, that was demonstrated in the popular local government autonomy judgment of last year, I think 11th of last year, where the Supreme Court have, as a policy court, have to consider the hardship being suffered by the people of Nigeria and interpreted the law as it ought to be. So in the final analysis, we beg to see that progressive, that charismatic approach to constitutional interpretation and the exercise of their powers under Section 6 of the Constitution, where the end of justice must be law. Law as an instrument of social justice, law an instrument of peace and harmony, law as an instrument of a social engineering theory, and law as an instrument of social harmony. In the final analysis, that all the actions of the sole administrator of Rivers State, which has not enjoyed the force of law, will be nullified. It does not even matter whether the Fubara, when restored, seeks to say, "Oh, I accept the result."
He stayed away
yes,
from.
He does not even have the power to accept it. He cannot ratify it. It is an illegality, founded on illegality, and the sole administrator cannot even appoint the chairman of the RISEC, because in law we say delegatus non potest delegare. He was appointed by the president. He cannot sub-appoint because a delegate cannot sub-delegate.
Thank you so very much. No better place to drop the anchor there. Samson Itodo from our offside studio is Executive Director of Yaga Africa. Thanks for coming on Newsnight.
Thanks.
And
thanks for having me.
Vincent Otaokpukpu is a constitutional lawyer and a public affairs analyst. Gentlemen, very warm appreciation for being part of News 9.